admitting more people into the Zoom meeting. So if you just joined us, I want to welcome you again. This is Estate Planning 101, and I'm Katie. I'm a librarian here at Lyon Township Public Library. I do adult services, marketing, and outreach. I'm happy to answer any library questions you may have. If you're not familiar with Zoom, if this is your first time, thank you so much for joining us online through Zoom. There is a chat function, so it's located in the bottom middle of your Zoom. So if you click on the little icon that looks like a little speech bubble, there will be a little chat box that appears to the right of your screen, and you can type in there. I want to thank Josh for taking the time to spend an evening with us tonight. But before I turn it over to him, I'm going to go over a few housekeeping details. So we are recording this Zoom event, so we'll be spotlighting our presenter, and I just want to let you know that you won't be featured in the video. I have enough Zoom experience now to know that. But if you feel more comfortable, you can leave your video off. If you want to, you're welcome to turn it on. I'm going to keep everyone muted, but you can use the raise your hand function or the chat option to ask questions, or request to be unmuted to ask a question to Josh directly. And I'll be monitoring the chat. So if there's anything disruptive during the Zoom meeting, whether through sound or video, I just want to let you know it may result in your dismissal from the meeting. We just want to make sure everyone can enjoy this shared event in a comfortable and safe online environment. So next, I want to invite you to participate in a few of our upcoming virtual events. Tomorrow at 7 p.m. is a special news guard presentation on how to spot fake news and misinformation. And again, that's at 7 p.m. More details are available on our event calendar online at ltpl.org. And then Thursday, October 15th at 6 p.m., please join us for an all ages trivia night using Kahoot. So you do need to sign up for a free Kahoot account, and you can download the free app onto your tablet or phone. The theme is Harry Potter. So if you like Harry Potter, I think you'll really enjoy this event. And then Saturday, October 17th at 10 a.m., we're hosting a trainer who does Zumba, so it should be a good time. And then I just want to let you know registration is required for all events just like this one. We're continuing our virtual programming through the end of the year. Lastly, we welcome your feedback if you don't mind. It's in a form of a short survey which will be emailed out to you tomorrow. And we just want to know what you thought of the virtual event, any feedback, what's working, what's the best way of communicating with you, and any ideas or topics you'd like to see in the future. We appreciate everything that is shared with us, and we take it into consideration when planning future programs. So just look for that tomorrow, and it only takes a minute. So we'd appreciate that if you would fill it out. So it looks like, yay, that took about the right amount of time. Without further ado, I welcome Josh and turn it over to him.
Hi guys, my name is Joshua Bassoon-Dath. I am a lawyer. Yay, everybody loves to talk to a lawyer, right? So what we're doing today is Estate Planning 101. What I found throughout practice of law is there's a lot of misconceptions, as with everything nowadays, but there's a lot of misconception with estate planning and what's entailed with it. So I thought it would be nice to do this like Estate Planning 101 and kind of go through what I see frequently and kind of get you used to the different terminologies and different tools that we have through the Michigan legislator to enact in order to go through. So if you bear with me, I'm going to share my screen. We're going to have a chance for questions all at the end, as we said before. So if you have questions, please put them in the chat, which I guess it depends on where you're seeing my video screen, but that way. Please put it in the chat, or we'll open it up to audio so you guys can ask at that time. So bear with me one second. All right. All right. Can everybody see the screen now?
Yes.
All right. Cool. All right. So estate planning 101. What's an estate plan? So the best way to describe it in super basic terms is we take your wishes, we take an attorney, we put them together, and we get the laws of the land going, and we're good. There's different types of tools. Some of the biggest, the three that we're going to talk about today, is going to be the wills, trust, and intestate. Intestate's an interesting topic, which we'll get to. So we're going to start with wills. Wills is the most common thing people know about. Everybody is familiar with them. You understand what we're doing with them. There's actually three different types of wills that you can have. The first one is statutory. Then we have what we call a holographic will, followed by drafted, or a traditional will, which is where an attorney drafts it. So with the statutory wills, Michigan has done us a great favor and laid us out an awesome little set of guidelines that basically it's a drafted form within the legislature in the statutes of law that they actually passed. And it tells you exactly what's required, and it's kind of a fill in the blank form. Michigan's made it real easy. However, I do want to preference the issue that comes out with statutory wills is it's super easy, and it's super easy to mess up. Other than a traditional will and holographic will, statutory is the second most contested types of wills in Michigan. A lot of times people think, oh, it's just simple, and they see these blanks and they're like, oh, I could just fill in the blanks, and they do, and that's great, and it will work. It's not, I mean, otherwise we wouldn't have it, right? However, I will tell you, it does cause a lot of contentious, because if you put the wrong wording, if you say something wrong, or even if you put the comma in a different spot, you can totally change the meaning. Leave it up to a lawyer to overcomplicate the comma, right? But it's happened, unfortunately, and so you want to make sure that if you're using a statutory will, that you're doing it with very high caution. Also, I should say, the lawyer brain in me, anything that we're talking about today should not be contested. I mean, not be taken as legal advice. This is strictly just an information session. This is all stuff that you can Google yourself, so I'm allowed to tell you this on camera and in recording. It is strictly just for more information and is not intended to be legal advice. Back to statutory wills. The statutory will, like I said, it's a great tool. Sometimes people just need to get something out there, and that's what they use. And you can find it by just Googling statutory wills for Michigan. Again, I'm going to preference use with extreme caution. Misplacing a comma can really change your entire idea behind what you wanted to do, and can lead to a lot of contentious and even lengthier and more costly issues down the road when your loved one comes into my office and needs help because something's not quite right, and the probate court won't take it. So that being said, holographic will. So this is a second type of will allowed. Most people have seen in the movies where somebody's in a bar, they're normally drinking, and they write something on a napkin, and it becomes their will. They die the next day, they die that night, it's their will. You think it's out of a movie, but it's actually not. It's actually a true case, which established holographic wills. A guy wrote a $100,000 contract on a bar napkin, and the court actually upheld it and said that bar napkin is his last will and testament. In Michigan, we have put some constraints on it. It has to be in your writing, so your own handwriting. It has to be dated and signed at the end of the document. As just with statutory, this is the #1 contested will. And when I say contested, what I'm talking about is somebody is saying, that's not their right will, that doesn't look right, they were arrested. Think of it as being forced to write. These things, especially when we're dealing with will. in Michigan are valid as long as you use with. Again, advice is to seek to do your small estates, large problems. That was like I don't know how many times my law professors drilled that into your head. It's always the small estates with the large problems. What we talk about when we talk estate, I think a lot of other clients I've seen come into the office have this misconception that estate planning is like something for rich people. Like, oh, I ain't got a lot of stuff. I just got a house and a car and a dog. An estate is any of your possessions from start to finish, as well as anything that might be in your name at one point or another. So the whole idea, I think I'm getting ahead of myself. We'll get back to that. Sorry, I jump around a lot. It's my brain doesn't work correctly. Attorney drafted document. So this is the third type of will. This is the most traditional set will. My favorite movie is there's a lawyer that comes in and he's a little old Southern lawyer with a cane, and he walks in and he does a reading of the will. That never happens. I was actually very, very upset that that doesn't happen, because I've always thought of myself as being overly dramatic, and I was waiting for that, like the gasp and everybody fainting because somebody left something to somebody else and I got to read it. It doesn't happen. It's a very boring process, really, especially for people who aren't interested in it. So attorney drafted documents by a licensed attorney in Michigan, because it is required here in Michigan to be part of the bar to draft an actual will, is the most uncontested. And we have in Michigan what we call the self-proving will. So as long as the will is typed by a licensed attorney, it's signed, dated, and we include an affidavit with that saying that you're under no duress and that you're of sound mind. It's kind of hard to beat. I mean, the lawyer, if anybody contests the will, they're going to bring it to the courtroom and they're going to read it and see that it's a self-proving will. And they're going to say, there's really nothing you can do to contest it. That's not to say you can't. It's just a very hard hurdle to jump over. So that's why most attorneys recommend doing this attorney drafted document of a will. I got really fun and fancy with the presentation, so I'm enjoying the graphics. So sorry if it's a lot of movement. Oh, there we go. So that's wills. Trust. This is what I find people get the most misconception about. So I don't know if I'm used to an interactive teaching experience, so this is a little new to me. I'm sure most of you have heard of what we call Susie Orman. Susie Orman is a lovely lady online who has all these great little, you need a trust. And she's always talking she's super into this, right? The problem with some of this is not everybody needs a trust. A trust, just for you guys to understand, a trust can $1,000 to get it established. A will can start anywhere from 800 is probably the lowest you're going to find, and go upwards. You don't need a trust. The whole idea behind trust or at least the Susie Orman group, I should say, and I'm not saying she's bad by any means, I'm just saying that it's not the full picture. People want wills and trusts so they can avoid probate court. Probate court essentially is what we call raising the dead hand. So let's say Ed, we're going to use a fictional character, Ed. Ed passes away. Ed only owned his home, but had a mortgage on it, but he still owns it. Ed didn't have a will. He didn't have a trust. He didn't do anything. He was like, I don't really care. I'm going to die. It's your problem. I hear that comment a lot, and that's fine. But now what happens is that Susie, Ed's daughter, has to do something with this home. It can't just sit there. In Michigan and almost every state, in order to transfer a home in ownership, you have to sign a deed a deed to your home, a deed to the property, all of that. Ed's dead, he can't sign it. So what we do is we go to a courthouse and we say, hey, court, I need you to essentially give me the power to sign for Ed. So we're raising Ed's hand. I figured it was a little gruesome, you know, raising the dead hand, but I figured it's close to Halloween, so you guys are fine. So we sign the document and then we can transfer. The problem becomes now Susie, instead of just paying the money up front from Ed, Susie now has to go find a lawyer, go to probate court, get on the docket. And I don't even want to talk about the docket currently because, as you all know, we're in a global pandemic. Courts are shut down. I know the other day, I just found out that one of the court systems that I deal with in Lower Michigan had a COVID scare. So they actually had to shut down for 2 weeks and clean, which means nothing was getting done. So it just pushes it back and back and back. Well, what's happening then? You have taxes, you have house payments, you have all this stuff happening. And we just got this house that Susie can't get rid of. That's kind of the gist of estate planning. It's to avoid probate court. Not all the time. Sometimes it's better to go to court and deal with it there. These are all, the problem with explaining estate planning in truth is it's very case specific. I can't really tell you this is the best way for everybody to go. That being said, trusts are a good way of going in a lot of instances. Trusts can also be very complicated. People think they're these major monsters of legal jargon. But the best way I can think to tell you guys about it is to think of a bucket. A trust is nothing but a fancy bucket. So we form this bucket, and then we have what we call, you have to fund the bucket, meaning we have to put stuff in the bucket. Otherwise, you just paid for a very fancy bucket that's empty. So most lawyers, when they create a trust for you, they basically create this bucket, this fictional person, and then we tie everything, that all your assets, your house, your car, we retitle them and redeed them into the trust. Then that way, if something happens to you, unfortunately, the trust lives beyond you. So the trust actually we don't have to go to probate court. We can just say, nope, look in the bucket. She kept it in the bucket. We're good. Trusts are expensive. Trusts are somewhat complicated for lawyers, I should say. Most of the time, we're just going to tell you, we're going to form a trust. We're going to get you going and you'll be fine. And then we create a will that says anything I forgot to put into the trust, when I die, everything goes to that trust. That's what we call like a reserve. It's like our safety net. So it basically says, okay, she bought a brand new, you'd think I'd be a car guy, but I'm not. I don't know, a really expensive Tesla. She bought a really expensive Tesla. It's like $200,000. I'm not even sure if they are, so forgive me if they aren't. $200,000 car, but she never put it in the trust, and then she died and she never said who got it. Well, that's an issue. But if we have that safety net will that we add to the trust, it automatically happens, so to speak. Nothing automatically happens in the legal field, just so you guys know. I like to think it does. It does not. So that's trust in a very broad nutshell. The best way to tell you guys to think about it is it's got to be a bucket with a spigot at the bottom, right? If nothing's in the bucket and I open the spigot being when you die, nothing comes out. What's the point? Susie Orman kind of made herself famous, in my opinion, to some lawyers because she was selling these buckets but never putting stuff in the bucket. That's where the issue comes out. My own grandparents, I'll use them as an example because they don't care. I've asked them before. They bought a bucket from Susie Orman, a trust, and then came to me after I got barred and was like, hey, do we need to do anything with this trust? And I was like, well, did y'all do anything beyond buying this bucket? No. So you just bought a really expensive 12 pages of paper. That's what they did. So that's something to be mindful about and something to ask if you're going to do a trust. Ask whoever who's doing that, hey, are you funding this? Or what do we do next? That's the important part I want you to take away from this. All right, enough about my bucket. I'm tired of saying the word bucket. Sorry, let's see if I can do it. There we go. All right, intestate. I ain't rich, so I don't need an estate plan. I like to think of, and this is a disservice to Southerners because I am one, but I like to think of the Clampetts, you know, the Beverly Hillbillies, because they just went from rags to riches and they never talked to a real lawyer. They only talked to a banker, right? So I like to think that they never had an estate plan. It's a whole new episode I'm thinking about pitching. But anyways, so an estate plan. A lot of times an estate plan isn't needed. Let me rephrase that. A lot of times certain aspects of an estate plan are not needed. This is the case for people who don't have a ton of possessions. That does not mean that we need to not do anything. Talking to a lawyer is going to allow you to at least determine what area I need to look. Do I need to look into the trust area? Do I need to look into the wills? Some other really cool tools that we have is what we call in Michigan, and its colloquial name is a Ladybird Deed. I'm not going to go into the legal jargon name because one, I don't know it. I mean, I do, but two, it's a whole bunch of stuff that makes no sense to people. A Ladybird Deed essentially is allowing you to put a beneficiary on your house. It's cool. It's one of the coolest legal tools I think I've ever seen. So basically what happens is we retitle your deed. I get your deed, or whoever gets your deed. We type it out, but in the jargon of legalese that we call, we're going to put, upon my death, the house is now going to belong to somebody else. So Ed would go, I get my house, I get to do whatever I want with it for the entire life. I could sell it, I could mortgage it, I can rent it out, I can do what I want with it because it's my home. However, it's only my home until I die. After I die, it's going to go to Susie. So what happens is, instead of going through court and having to transfer a deed and do all this fun stuff, it automatically happens. Why is that important? When we're dealing with smaller estates, the need for Medicaid comes up sometimes. If you're not familiar, and it's a whole nother lesson, but Medicaid is essentially a government-funded assistance with nursing homes, assisted living, a whole variety, and it changes monthly almost, it seems like, from a law standpoint. So what they have is, in that issue, is what we call a divestment. The Medicaid company, the Medicaid office is going to take the moment you apply, and they're going to look 5 years backwards and say, did you give anything away in those 5 years to qualify for Medicaid? Well, sometimes when you create a trust, that can be considered a divestment. You're doing it for peace of mind. They're looking at it like, oh, you tried to get rid of your house that's worth $500,000 so you can qualify for Medicaid. And then what happens is, when you pass away, they're going to either penalize you while you're alive and say, okay, we're not going to pay you any kind of Medicaid stuff for the next 10 months because that's the money we've allotted. Or they're going to say, oh, okay, well, when you pass away, we're going to collect from your estate, and then people can have at it afterwards. The Ladybird Deed is cool because it kind of says, well, it's their house for now, and then we're going to hide it when they die, because the second they die, it actually transfers to whoever we left it to. It's the coolest thing because I don't want to say it's hiding it from the government. That sounds nefarious, and I'm not condoning any kind of nefarious, crazy spy thing with the government. It's just a legal tool created by law to help us out. This is all stuff and reasons why I always say, go to an attorney. It's not just to propagate, my industry. It's truly, they're tools that people don't realize are out there to help you out. I got off topic with Ladybird Deed and just realized that we're on intestate. So what happens if you pass away suddenly? Let's say tonight, you go out, you decide to go to Dairy Queen for a banana cream pie blizzard, which, by the way, amazing. You go out for that and you get in a car wreck. It's awful. It's horrible to think about, but you didn't do any estate plan. What's going to happen? The state has said, no, well, we got you. And they've put in a place where they actually have already said, this is how we do what we call intestate. That means I don't have a will or an estate plan. They've come in and said, okay, your possessions are going to go to this person, and then to this person, and then to this person. If this person's dead, we're going to go over here. They've laid it all out. Sounds great. But again, guess where we have to go? Probate court. Probate court has to be opened on your case. The court has to review it. Somebody gets put in charge. Sometimes it's not always the person that you would think. If the court says, I don't think Susie's capable of handling Ed's estate, I'm going to assign some random person or another attorney that works for the court to handle that. That's not always the case, and these are always worst case scenarios. There's nothing worse than not understanding that lawyers always think in worst case scenarios. But it's out there. Intestate's great because it's not just oh, we don't have anything to do, the government gets it all. It's definitely the government saying, no, we considered a plan for you. It may not be the one you wanted, but you didn't do your homework, so we're going to do it for you, and we're going to do it the way we want it. It's kind of like, moms. All right, if you don't do it, I'm going to do it, and you're not going to like the way I'm going to do it, right? Actually, I should say moms, wives, all of that. I say that kind of stuff in my house all the time. If y'all don't want to do the laundry, I'll do it, but I'm doing it the way I want. Same idea. So that's what we mean by when we say intestate. Hopefully nobody in this class or conference, I don't know what we're calling it, seminar, hopefully you all go out of here today with going, I need to make a plan because I don't want Michigan doing my stuff for me. All right. Gotta love the zooming. All right, so the medical directive. So now we've established your estate. We've taken care of the junk, the heirlooms, the money, all of that. Now we kind of get moving into what I still consider part of a comprehensive estate plan, which is a medical directive. Medical directives are basically, all of you at one point or another have probably filled out some form of medical directive when you go into a hospital for surgery, that kind of thing. It's those forms that you fill out before you get there, or when you're in the waiting room and everybody's coughing on you and you're trying to write and your kid's screaming, and yeah, that one. So these are kind of things that I like to tell people to look at before drafting a medical directive. This is going to tell you what we want to do in case of emergencies. So are you in a coma? Okay. Do you want life support? I'm not sure if you guys are familiar with the Terry Schiavo case in Florida. It was a big case. I'm trying to think of how old I was, but we'll just say I was 11. I know I was much older, but I like 11 because it makes me seem younger. Terry Schiavo, unfortunately, was put into a medically induced coma and didn't have medical directives, didn't talk with their family about it. And we had mom and dad saying, and forgive me, whoever's watching this, mom and dad were saying either pull the plug or keep the plug. And the husband was saying, no, pull the plug or keep the plug. They were in opposition. It became a big, knockout, drag out court battle for months. I think it even went on for over a year before they finally decided something. And she spent this entire time in a medically induced coma with feeding tubes, and even just the idea of the family having to decide, do we pull a plug? Do we not pull the proverbial plug on her? What are we going to do? Medical directives help us avoid that. So not only do we talk about carrying on wishes beyond you, your ability to make them, we talk about stuff even while you're alive. Do you want life support? What do you consider life support? Is it feeding, hydration? Is it medications? A DNR. A DNR is what we call a do not resuscitate. So this is basically if there's no hope for you, do you want them to try to resuscitate you as best as possible? In the past, I've seen clients say they do want a DNR. Oftentimes for our much more elderly people, DNRs can actually hurt more than they help. Resuscitation can sometimes crack ribs. I've heard the horror stories. It can do a lot of damage while they're trying to resuscitate you. So a lot of elderly people are like, no, if it's my time to go, it's my time to go. I'd rather go and not have to deal with extra stuff. And then we have mental health, which is a big thing right now, right? If for some reason you need to be committed against your will to help with mental health issues. Do you want that to happen? Do you want your husband or wife to have that ability to do that? Do you want your mom to have that ability to do that? Your sister, whoever it is that you choose. And then medications. So this is what we call palliative care. Palliative care is essentially, let's say Ed, we'll go back to Ed because we've already killed him once. Ed's in the hospital and he's in a coma and they're saying he's only going to live for the next 2 weeks. Well, the doctors come to Susie and say, okay, Ed's going to only live for about 2 weeks, but he's in extreme pain. If we give him medication, it will alleviate his pain completely or substantially, but it's going to take those 2 weeks down to 1. Do you want that? Do you want 1 week of painless, or do you want to live longer so you have a chance to get what you need done and no pain medication? It's a hard subject and it's super heavy for Tuesday night, but it is something that I want clients and anybody to think about. Do you want that kind of stuff? These are all the steps and the different things that we do with medical directives that allow us, and it goes much broader. We can make these specific as you want. I want one attorney. I want one doctor who I've never seen before, and I want a second doctor who's my primary care physician to make these calls. I mean, we can go as specific as you want or as general as you want. Do you want, maybe it's your sister. You and your sister have never parted ways. You're super close. She knows everything about you. So do you want a medical directive that just says, I want her to make the decision because she knows what my wishes are? We do those as well. All right. The durable power of attorney. I always like to approach this with a lot of caution. Not any more so than the medical, obviously, but a durable power of attorney is also what we call a financial power. This is somebody that we're going to allow to make payments in your behalf. They're going to pay your bills. They're going to do this for you. They're going to help you with your selling of your home. This is all stuff done while you're alive. You may be unconscious. You may be in a medical, in a surgery, all that fun stuff that where you can't make these decisions. This allows them. The reason I always invoke caution on this is a lot of times it's drafted to be considered not springing, meaning there's no triggering effect. So the moment you sign it, it's valid, which means that person has full ability to be your financial equal, meaning they can do anything you can do, they can do with your money. So it's always something I caution clients about, and friends, family, you guys. Look at it and go, do I really need this? Is there another way around this? If I do need it, I trust whoever I'm naming as my durable power of attorney 100%. You see these a lot with like military. When I was in the military, I had one. It was my mom. I trust her at the point. I mean, I still do. Mom, don't hate me. At the time, I trusted her 100%. I still trust her 100%, but I have other people to do that for me now. So that's kind of where those come into play. It is a tool that we use quite often. However, it's one I very strongly recommend you doing with extreme caution, given the amount of power they have with money, which is a lot of our concerns. In an elderly state or even a young state, it's a concern. Before I go to the questions, I do want to, and you're going to have to kind of help me with this. I'm sure you can see it on my screen. I've managed to put my logo any and everywhere possible on it. This is kind of an FAQ, frequently asked question. I always get them all the word jumble mixed up. I believe this has been put on the library townships, or it's going to be sent out to you, I believe, in an email.
Yeah, I'm going to see if I can do that. Let me.
Okay.
Yeah.
So this is basically everything we talked about today. I kind of wrote it down. This is something I give prospective clients when they're trying to decide. A lot of times I have people just like, oh, I need to get one. Okay, well, go over this. This is going to prompt you with questions to ask. What will happen to me if I end up in a coma? If I were to pass away, do I want my body donated to science? Do I want my organs donated to organ donation? These are all questions that you really should contemplate. And if you're married, or if you're not married and you have somebody significant with you, you want to go over these with each other because you don't want any surprises. Nothing's worse than having somebody sit in a law office and learn that they want their body donated to science from their loved one. It's a very awkward situation for all three involved. So it's something that I really recommend. These are also commonly asked questions from people. It just kind of goes through it and tells you exactly what these different definitions are. I know I'm scrolling fast, but I promise you it's all the stuff we talked about today. And then how do you start your estate planning process? So the first thing that you need to do is, I'm going to say, contact an attorney. Most estate planning attorneys will not charge you for the first consultation. And that's when they decide, like, okay, this is where I would think that we need to go. And they just sit and talk to you. That's always a good thing to know, because anytime you can get free legal advice, get free legal advice, which this conference is not one. This is just legal information. So contact a lawyer, make sure you understand what is your game plan or what would best suit you. They're going to be the ones that are really going to be able to dig in for you. I even have some more questions when it gets down to like investment accounts. The other good thing that a lot of state attorneys will do is make sure that your investment accounts and everything have what we call a beneficiary on them. Then there's no need to worry about it, right? If there's a beneficiary named, it's already taken care of. But that's the job of your estate planning attorney. They're going to look at that and go, okay, you're good. We got you. Everything's set. You're squared away. And you're all good to go. So it's just some questions. Look over them. I have included at the bottom my contact information. If you need more information beyond our questions, I'm happy to talk to anybody, or any other lawyer would be happy to. I know there's several of them. My contact information is there at the bottom. I'm sure you can always reach out to the library for contact information. They know how to get a hold of me. So at this time, I think what I'll do is we'll open it to questions. But I got a slide for that. I just want to use it because I use my slides. I made it. So, all right, questions. Am I in full share? No. I don't know if we have any questions on the side. Well, I'm glad I asked you because I have messed this up and I can't figure out where to look.
Oh, I don't see anything in the chat yet.
Okay.
We do.
I'm on a telephone.
Oh, yes.
Can you hear me?
Yes. Go ahead. Can you give me your name just so I know?
Catherine Kozowski.
Catherine. Hi, Catherine.
Hi. All right. All trust goes through probate according to, and I can't think of the judge's name over in Oakland County. He's the oldest one there. And he mentioned that in the last hearing I was at, the probate hearing a few weeks ago.
Well,
so if there's a will attached to a trust, does that will have to go through probate?
So what happens is and what I don't know which judge, and I don't know what he was exactly talking about. What I can tell you, which often gets confused, is no matter what happens, no matter what tool we're utilizing, all of it will have to be at one point or another brought up to the probate court. It's just whether or not we have to go in front of a judge. So what happens is if you've done the estate plan and we got you settled, you may not have to even go in front. Your lawyer may take your documents and go to the court and see the county clerk and say, I need to open this estate so I can deal with the will and close it. And they stamp it. You never go in front of the judge. You never see that judge. So that might be where it's going into probate. It's not necessarily always in probate. Probate's only if we need to determine something in the will or in the trust that was ambiguous, or there was an issue, or that kind of sort of contested issues. But that's only in front of the judge. There are other ways. We all have to deal with the probate court. It's just a faster process if you have these tools.
All right, I have another question. In a situation where there's no will, no trust, no nothing, the husband is dying, they're both married 35 years, there's some properties in his name, and her name is not on it, Does it automatically go to her?
It will go to her. It won't be what we consider automatic. If they're married in Michigan, we have a community property, so they own it. It will all go to her, especially under the intestate rules, because that's the first thing they look at is the spouse. Depending on the deed and how they own the home, I'll preference that because there are certain ownerships in homes that don't transfer. Again, that sounds more of a specific thing. I'd have to look at the deed itself. But if it was like your basic home deed, it would just go to the wife. Again, because we didn't have an estate plan, we would have to go to the probate court to transfer the deed.
2 last questions. Ladybird Deeds, when do they get filed? While you're alive?
Yes. So I actually, personally, when I draft a Ladybird Deed for a client, I send them out the door with the deed rewritten and I go to the deed office of their county and I look at all their requirements. I write draft the deed. I give them a little sheet that says you need to go to this office at this address. It's going to cost this much to file the deed. And I recommend they do it that day or the next day. Because again, it's not valid until it's recorded.
Now, is that true through all of the counties in Michigan, or is it different in different counties? And if properties are in different counties, then you'd have to do different things.
Are you still talking about the Ladybird Deed?
Yeah.
Okay, sorry, it cut out there at the very beginning. Like every county is going to, you can do a Ladybird Deed in any county in Michigan. You do have to register that deed in that particular county's office.
Okay, so you would have to go to each property and register it in the county it's in.
Yes.
Okay.
I will tell you right now, I generally tell my clients, here's the information. Call them first because COVID is changing so many processes. Processi? I don't know what the correct plural. Procedures that we're doing right now. So you want to make sure that you don't make a trip out there and then everything's by mail, that kind of thing. Right. But yes, you will have to go to each county individually to register it.
Okay. Is that same with international?
I cannot speak to that because I don't practice international law. I only practice Michigan currently.
Have you ever come across it?
I have not. I could say there's a few cases that we learned about in law school, but it was kind of one of those, out of sight, out of mind things. You'd have to look up an international attorney or an attorney that practices or what they call a solicitor in other countries. You'd have to look up one of those in that particular country for the best answer to that.